I believe we have the next witnesses online. Yes, we do. Okay, I now welcome representatives of the Association of Financial Advisors. Thank you for appearing before the committee today. Information on procedural rules governing public hearings has been provided to witnesses and is available from the Secretariat. When answering questions, please speak clearly and please speak into your microphone and ensure it's off if you're not speaking. I'd like to advise you that questions on notice should be provided back to the Secretariat by close of business 22nd July 2021. I invite you to make a brief opening statement in a moment, and I just flag two things. Firstly, please keep your opening statement to 2 to 3 minutes so we can have questions. And before you make your brief statement, I invite you all to state your names and the capacity in which you appear.
Thank you, Chair. Phil Anderson, Acting CEO of the Association of Financial Advisors.
Michael Nowak, I'm the National President of the Association of Financial Advisors and a practicing financial advisor as well. Thanks for having us.
Senator Sam Perera, National Vice President of the Association of Financial Advisors and also a practicing advisor.
Okay, go ahead.
Thank you. And thank you for the opportunity to appear at this hearing. The AFA is a professional association for financial advisors. We have over 3,600 members, the majority of whom are small business financial advisors. The AFA supports the introduction of a pragmatic disciplinary system for financial advisors, including access to a broader range of penalties. It is our view, however, that the single disciplinary body should be focused upon more serious misconduct and not minor and administrative matters. Finding the right balance is critical. We are concerned that the single disciplinary body's inclusion of minor and administrative matters will result in a large number of matters being investigated, placing pressure on resources and cost. While Section 139(2) of the ASIC Act enables regulations to limit the type of matters that would be considered by a Financial Services and Credit Panel, Section 921S(1) of the Corporations Act requires ASIC to issue a written warning in the event of a breach of a financial services law where they have not convened a panel. All breaches, no matter how minor, will need to be investigated by either ASIC or a panel. Financial advice is a very complex and tightly regulated profession, as has recently been recognised by the Australian Law Reform Commission. The sector is already subject to stringent supervision, monitoring and reporting arrangements, including comprehensive file audits, supervision reviews and self-reporting of issues. The AFA has concerns that the new breach reporting regime that starts on 1 October will lead to an exponential increase in minor matters being reported to ASIC by financial advice licensees. We also believe that it is an extremely complex piece of legislation that is very difficult for licensees to understand and comply with. The single disciplinary body will consider substantially more matters than those captured under the reportable breach regime, due to the fact that the single disciplinary body will consider all breaches of financial services law and not just certain civil penalty and offence provisions. We believe that the matters that are referred to the SDB should be limited to the significant breaches that are reported to ASIC. We support the review of misconduct by a panel, including appropriately qualified peers. We also believe that each panel should have at least 3 members at all times. We recommend that only serious misconduct is recorded on the Public Financial Advisor Register. Matters subject to a written warning or reprimand should not need to be published on this register. In the context of the 112% increase in the ASIC funding levy to $2,426 per advisor last year, and with a further increase expected for the 2021 year, it is critical that the cost of the single disciplinary body is carefully considered and controlled. No regulation impact statement accompanies this legislation, and the suggestion of low compliance cost is most improbable. We recommend that any revenue raised through the application of infringement notices should offset the cost of the single disciplinary body rather than being paid into consolidated revenue. We support the transition to an individual registration model for financial advisors, although recognise the important ongoing role of licensees. We support the winding down of FASEA at the end of 2021 and the transfer of existing responsibilities to the Minister and ASIC. There is more work for FASEA to do over the remainder of 2021, including the ongoing administration of the exam and the review of the FASEA Code of Ethics. It is our view that there is still room for sensible changes to some of the FASEA standards, including better recognition of prior study, as expressed in the 2017 Professional Standards Explanatory Memorandum, and an increase in technical and reduction in ethics hours that are required under the CPD standard. We are strong supporters of the proposed limited extension for existing financial advisors to complete the FASEA exam and have persistently advocated for a pragmatic transition given the volume and pace of change impacting financial advisors. We support the intent of the legislation to remove duplicative regulatory registration and oversight of financial advisors under the TASA TPB regime. We believe that financial advice should be completely removed from the TASA regime. Tax-related education and CPD standards should be a part of the overall financial advisor education and training standard and not as a separate standard. Thank you for the opportunity to address this committee. I'd also like to close by reiterating our absolute commitment to advancing the professional standing of the financial advice community, whilst also advocating for sensible policy settings that will enable the sector to thrive and more Australians to access affordable quality financial advice. We're happy to answer any questions.
Thank you, Mr. Anderson. I will offer the first block to Senator Walsh if she is ready.
I am. Thank you very much, Chair, and thank you all for being there. You've said in your opening comments there that you're supportive of winding up FASEA and transferring responsibilities, but there are some aspects of the work of FASEA that you'd like to see, continued in the new model. Can you just give us a bit of an overview of what the challenges were that you found with the FASEA model, and also what are some of the things that you'd like to see taken forward?
Thanks, Senator. I think probably some of the key issues were that we didn't feel that there was an effective consultation on some of the standards. We think some of the standards went further than they needed to and neglected some of the intent of the Parliament. And in our opening presentation, we specifically made mention of recognition of previous study, where the explanatory memorandum referred to the ability to recognise previous study, including continuous professional development that had been undertaken. And the standard as we have it does not include doing that. In terms of the other point that we made was that with the CPD standard, it was raised to 40 hours per year. Only 5 hours of that is technical knowledge, whereas 9 hours is ethics. And we feel that the balance needs to be brought back into that so that there's more technical requirement, but maybe not as much in the ethics space.
Thank you. And in relation to the constitution of the panel, just a couple of questions. Are you currently satisfied, or do you have any input around the constitution of the panel and ensuring that there's relevant industry-specific experience on it? And then you also raise a specific issue in your submission around if panel members are disqualified, that it could be the case that only an ASIC representative might be making a determination, and you point out a lack of clarity there in the bill. So could I put those two questions to you?
Yes, Senator. We made the point that financial advice is a very complex area with very broad legislation. The Australian Law Commission said that Chapter 7 of the Corporations Act is on its own would be 11th or 12th biggest act in the Parliament. It is very complex. It is has many obligations. So we're making the point that we think that people on the panel do need to understand the law deeply, and they do need to understand the advice process. So that's one of the points that we make. The other part of your question was with respect to if someone is disqualified because they have a conflict of interest, which we've said we would like to see further guidance on, then we believe that they should be replaced by someone else. So there's always at least 3 people on that panel.
And have you given any feedback to the Minister or Treasury in this process on that? And have you had any response to that concern?
Senator, we provided the same response when we responded to the exposure draft legislation, and equally with this, we are also providing that feedback.
You've raised in your opening statements and also in your submission this question that a number of people raise around the additional education requirement for tax advisors, and you say that it shouldn't be necessary. Can you expand on that for us? What is the current problem that you're seeing there, and how would you like it to be addressed for your members?
Well, there's a few factors here. The first one is unnecessary complexity. Let's just have one standard for financial advisors that includes a requirement for understanding and knowledge of the tax requirements. Let's build that into the core requirements rather than having a separate standalone education standard for financial advisors providing tax advice. We have said in our submission that we think all advisors need to have some level of understanding of tax, and that just about all financial advice has a tax element to it. So we think that one standard should address that, but we've also cognizant of the fact that there are certain arrangements that are in place at the moment that don't lead necessarily to a clean transition. We've referred to the Tax Practitioners Board model of sufficient numbers, where some financial advisors aren't actually registered with the TPB, that they are covered under someone who supervises them. And a similar regime is not available through what is proposed in this legislation. So we think there's other issues with respect to the transition that have been raised by other submissions. So we think this is an area that does need to be looked at to make sure that it is a clean transition. The complexity is removed, so there's just one standard that applies to both education and CPD that covers all the tax elements that an advisor needs to understand.
Okay, thank you. And you submit today and in your written submission that you're concerned about the volume of work going to ASIC, and you're concerned about what you might consider to be sort of minor compliance issues being dealt with in this way. We've had other evidence just this morning that some witnesses have become sort of more satisfied on this question around the panel dealing with more serious issues and ASIC dealing with the more minor breaches. Can you tell us where your thoughts are today on the ability of ASIC and the panel to deal with the volume of issues, and expand on your concerns about any compliance costs of that for your members?
Thank you, Senator. I think the way to look at this is that there are already comprehensive processes in place within licensees. Each advisor is subject to an audit of up to 6 files each year, and these audits necessarily will identify things that come up. Some of them are really minor. And we've had the example earlier on about an FSG that is provided late, or an advisor hasn't provided an updated product disclosure statement, or they haven't provided an updated financial services guide. It could be that there's an error in a fee disclosure statement. It could be out by a few dollars. Maybe they haven't adequately documented compliance with each of the actions that they've taken with each of the steps in the safe harbour. There is a significant number of these minor things that will end up being covered within this regime. We're also conscious that while Section 139(1) of the ASIC Act provides provision for the minister to prescribe through regulation what things panels will look at, we're also conscious that under Section 921S of the Corporations Act, ASIC will need to look at all things that the panel does not look at, and their only option is to issue a reprimand or warning. There's no option under 921S to take no further action. So we're just very conscious that all of these matters, whether they're looked at by a panel or looked at by ASIC, will need to be subject to some level of investigation, and that involves resources and time. So we're just saying that there must be a more sensible way of ensuring that the single disciplinary body regime, in combination of both the panel and ASIC, is only looking at the more material matters.
Senator, if I could, I would add quickly, if that's okay, Senator Bragg, the impact of cost. And you spoke about the industry wearing the brunt of this additional compliance cost if the regime is inundated with minor administrative matters. But really, I would like to throw a consumer lens on it, and because these costs are ultimately borne by the consumer, and it is well documented. Your colleagues included in the Senate have spoken about the exacerbating crisis in relation to ordinary Australians being able to afford financial advice. So we see that as a significant risk as a result of this regime having to contend with dealing with minor administrative issues, and we are extremely concerned about the consumer impact in terms of the rising compliance costs.
Senator Walsh, your time has sadly expired, so I do need to hand the call to Senator Patrick, but we may be able to come back to you. Senator Patrick, you have the call.
Yeah, thank you, Chair. I just want to raise a couple of issues. One, in relation to evidence the stockbrokers gave to us, and that goes to education requirements under direction from FASIA versus what may occur under this legislation. Do you have a view that you might want to share with the committee on that?
Thank you, Senator. We have made a specific reference to this in our introductory comments. The education standard, and I know that the Stockbrokers and Financial Advisors Association has already spoken to this. What we've identified, though, is that the current standard that's been defined by FASIA does not adequately recognise experience for previous study, and in particular CPD that's been done by financial advisors. So there's a lot of longer-term financial advisors who are not getting any credit for what they've done in the past and required to do 8 graduate diploma subjects. We have, on many occasions in the past, asked that FASIA look at, again, what the government and what the Parliament intended in that explanatory memorandum that went with the bill in 2017 to better recognise previous experience, study and education.
So have you had discussions with the Minister in relation to this?
Yes, Senator. Over the years, we have. Obviously, at the moment, the Minister has no powers with respect to this because the powers are delegated to FASIA. But we have equally raised this issue with FASIA in the past through various interactions and submissions that we've made.
Look, really where I'm going is that there is a change that would allow the Minister to address this issue or address your concern moving forward. And it's in that context, perhaps so not looking backwards, looking forwards, have you discussed with the Minister what may happen after the passage of this legislation?
No, Senator, we've had no detailed discussions with the Minister on this. I think ultimately it's up to the Minister as to whether the Minister wishes to look at this more closely.
Again, there's an opportunity potentially as this bill passes through the Senate for an amendment that might seek to broaden the scope or perhaps overturn the requirements of FASIA and indeed to having a broad requirement to recognise past training and experience. Is that something that you would welcome if that were to occur?
Senator, we would probably respond in a similar way to what the Stockbrokers and Financial Advisors Association said, in that the legislation does not require FASIA to have taken the standard to the point that they have, and the explanatory memorandum specifically refers to the ability to recognise experience through CPD and other study that advisors have undertaken in the past.
My point being, and you often see parliaments remedy mischief, for want of a better word, conducted, or perhaps courts make determinations, but the parliament says, well, that's not quite how we saw it, and they make an amendment to a bill or to an act. Again, we see things that occur in the real world, but that are complicated or inconsistent with, is a better word, inconsistent with what the Parliament had in mind. Look, I'll just say that, again, perhaps the offer to you, if you have a concern in this area, noting there's an opportunity to forcefully express what was only in an explanatory memorandum last time around, there may be an opportunity to change that. So perhaps, again, if you wish to contact my office. I might go to another question I have. That's in relation to these audits. I think two of you said that you are practicing. I just wonder if you could give an idea of the burden in your own experience in relation to these audits that you referred to. I mean, there's something in, there's a requirement, but does that hit every financial planner every year, or how is that being executed by a government authority?
Senator, I will refer to our two practicing advisors. What we're talking about is licensees doing audits of client files. So each advisor will be audited at least once per year, and they will look at as many as 6 client files in detail. This can be quite a comprehensive process, but Michael, I might refer to you on that.
Thank you, Phil, and thank you for the question, Senator. So, as a practicing financial advisor, we are required to have an annual audit which is, I guess, administered by our licensee. That does involve the review of a number, up to 6 we've got here, client files. So that's files where we have provided advice to a client over the course of the previous year. So in doing that, I guess the key issue that the licensee will look for in terms of compliance is that we have met the best interest duty and that the advice is in the best interest of the client. So with regard to the safe harbour steps, this needs to be demonstrated in the file as well. That's best interest duty in terms of in theory is great for in terms of consumer protection. It's a fiduciary duty. However, in terms of meeting the steps demonstrating that you've met the steps of the best interest duty, that can take a lot of time, and I guess is increasing the cost of providing advice. It requires a lot more time in onboarding a client because you need to have greater understanding of the client's circumstances. There's been a hesitation, which is quite well known within the financial advice profession, about scoping or scaling or limiting advice because of the new FASEA requirements, the code, in terms of having to be aware of all the client's circumstances. So it's been a lot more hesitation to do that as well, which means that advisors are spending a lot more time looking to understand their clients' needs and objectives to ensure that they are abiding by the best interest duty and the FASEA code of conduct, etc. So I think overall, there is a lot more compliance. The whole monitoring and audit regime probably isn't a step that takes a lot more time. It's just a combination of all of the rules, best interest duty, etc. that is increasing the cost of advice. I might hand over to Sam if there's anything you want to add to that, Sam.
Yeah, look, just
I really was trying to get an understanding of the time burden that's placed upon you. Is it a week of your time? Is it a day of your time? Is it a month of your time when you're dealing with this auditing?
Yes, generally, that it would take place over the course of a day, and perhaps once the audit is finalised, some hours in terms of the debriefing process, and then, of course, if there's any remediation that's needed, depending on the issues identified. But to tie it back into the point we make in our submission, Senator Patrick, is that invariably there are issues picked up as a result of these field audits that licensees take as a matter of course in terms of supervising their authorised representatives. So it could be something as minor as the file audit of the 6 files on an annual basis, picking up the fact that I failed to give my client the most recent FSG, and I gave them a previous the previous calendar year's iteration of the Financial Services Guide, and the propensity for this regime for that error or omission to be pulled into this disciplinary regime, because our interpretation of the 107 pages of the very complex legislation is that minor and administrative matters such as that will be dragged into this net. And what we're saying is that we don't believe that this regime should consider that.
Where I was going to was the client, or was the statement that you thought that the more serious, or your organisation says the more serious offences ought to be dealt with. The minor offences not. I'm just trying to work out, does the audit cover off on those minor offences? Yes. Related to that, if they don't, if there is some area in some of these minor offences that don't, and I haven't looked to the legislation, the sections you mentioned, but is it a may or is it a must in terms of what ASIC is required to do? Is there a discretion in there, and would a simple change from a word must to may give you greater comfort? A few questions.
This will have to be the last question.
Yeah. I'm happy to respond to that, Senator Patrick. It's the combination of Section 139 of the ASIC Act, which talks to how ASIC may call a panel, but the complication is Section 921S of the Corporations Act that says where there's been a breach of the law, however minor that may be, and ASIC has not chosen to convene a panel, that ASIC must issue a written warning or reprimand. And that means to do that, they must go through the process of investigating even the most minor of matters. So what our suggestion is in 2 ways, that ASIC should have the option to take no further action with a matter that they don't choose to refer to a panel. And secondly, the criteria for matters that can be considered through this should be elevated so that they're more a matter of significant breaches that would otherwise be reported to ASIC through the significant breach reporting regime.
Senator, can I just
We've got to move on, so you have to be very quick.
can I just say quickly, we would be happy to provide our suggestions on notice, Senator.
Thank you.
Great.
That would be helpful.
Okay, thank you. Just two quick ones for me before you go. Do you support this idea of having a single disciplinary body?
Senator, yes, we do support the idea of having a single disciplinary body,
Okay.
and we are broadly supportive of it. Our feedback has been in a few areas, but primarily making sure that it's focused on the more material matters in order to make sure that it doesn't unnecessarily increase cost, and that the tax advisor issues are rationalised so that there is just one standard and not an alternate standard for tax advisors sitting alongside the main standard.
Thank you. And you're also supportive of individual level registration, aren't you?
Yes, as we said in the introduction, we're supportive of that. We recognise that it won't happen immediately, but we don't dismiss the important role that licensees play. And we've talked about the audit process that they go through each year. So the regime has many different elements to make sure that advisors are held accountable and clients get good quality outcomes.
And finally, what is the legal provision you mentioned that forces ASIC to investigate every single matter that you mentioned before?
Senator, it's section 921S, and that particular section requires that where there has been a breach of a financial services law and it hasn't been referred to a panel, they must issue a written warning or reprimand. So it means that for every matter that's not referred to a panel where they've got reasonable grounds to believe there has been a breach of the law, they must still take action by issuing that warning or reprimand. And there's also provision that that warning or reprimand that is issued by ASIC as part of section 921S could be included on the financial advisor register. And we're not comfortable with that because with that particular provision, there's no basis for a hearing or submissions, so advisors would not have the chance to defend themselves. So I think it's inappropriate that a matter that gets identified through that process should end up being recorded on the financial advisor register, which is a public register.
And we would like ASIC to have the option to take a no action position in relation to 921S. That's the remedy we seek, Senator.
Okay, thank you very much, and thank you for your evidence today. I would invite you now to disconnect from the video conference. You can observe the balance of the hearings through the Parliament House website. The committee will now suspend until 10:45 a.m. Thank you.
Thank you, Senator.
Thank you, Senator.